Today on Categorical Imperatives, we are going to be talking about the seminal Supreme Court case of Cooper v. Aaron and the myth of judicial supremacy. Hey, greetings and welcome back once again to Categorical Imperatives. As always, I am your host, Lockie Liberal, and I do want to thank you all so much for being here with me today. Now, if you are new to this program, I want to welcome you. I've actually had a lot of new subscribers and a lot of new viewers lately, which is really exciting for me. So hopefully you people are new and you're finding this interesting. And so if you don't know, this is a podcast where we will be applying legal theory and moral philosophy to discussions of current events related to law, politics, and culture. And today, well, actually, first of all, real quick before we get to that, if I can just take a second here and whore myself out to you guys, I have recently opened up a couple avenues of funding for the show. You can do a one-time donation through Venmo, or you can do a monthly through PayPal, or you can sign up to become a Patreon over on my Patreon page. Rather than explain the reason why I'm doing this now, I've written a nice long kind of article over on my Patreon page that's available to everyone to see that explains why I am starting to seek funding for the show, and if you are interested and willing to help, what exactly your donations would be going towards. So I encourage you to take a look at that, decide if it's something that you are interested and able to do, and if you can, I would really, really appreciate it. So anyways, enough whoring myself out. Let's get to the topic for today. So, as I mentioned right in the beginning, today we are going to be doing a video that will be part of my Today in Supreme Court History video series, where we're going to be covering Cooper versus Aaron. This is a case from 1958. Now, usually when I do Today in Supreme Court History, the today part means that we are celebrating the anniversary of either oral arguments or the date that the court handed down its opinion in the case. That's not quite what this is. This is a little different than what I usually try to do. And the reason we're doing it today actually is something of a nod to Black History Month. Because even though I get the feeling most people will be unfamiliar with this case, it is inextricably tied to a case that I'm sure you will all be very, very familiar with, which is Brown versus Board of Education. This will be the true history of that case of Brown versus Board of Education. So I emphasize true history because, as you'll soon find out, Brown versus Board of Education did not do precisely what most people will tell you that it did. That is, it did not end school segregation. That came from a later case. That later case was Cooper versus Aaron. So we will be looking at that case and discussing what is really a truly fascinating narrative about one of the most interesting chapters in our republic's history, and what I consider to be one of the most fascinating chapters in the whole of American jurisprudence. Now, as always, I have all kinds of great links to sources and articles that I have aggregated with information, and I will have links to that down in the description below. Links to a lot of articles that I will be directly talking about, or just articles that maybe I don't get around to talking about here today, but are related in some way. Now, I just want to take the time to give honorable mention to two of them. The first one here is this article. This is The Irrepressible Myth of Cooper v. Aaron by a fantastic constitutional law scholar, Josh Blackman. You've probably heard me praise him on the show here before. I love the guy. And so this article takes a fresh look at Cooper v. Aaron, and it, through a lot of original research, draws some unique conclusions about the case that really were undiscovered before he did this research and published this article. And then also, I have an article here that I will link to that I wrote for the 10th Amendment Center. And if you don't want to necessarily commit to reading Josh's full 90-page article, which is just a dense 90-page law review article full of a lot of legal jargon, essentially what my article does is it covers the case and it covers all of Josh's research that he does in that article, and I condensed it down into a more conversational format while still being every bit as informative and now easily understood and helpful for lawyers and non-lawyers alike. So I just wanted to mention those two specifically. There's tons of links down in the description. I'd encourage you to check them all out. Now, the importance of removing the stain on the soul of our nation that has existed for over 50 years of the idea of separate but equal, that had existed for 50 years, I should say, of separate but equal, that had come about from the erroneous interpretation of the 14th Amendment's Equal Protection Clause in the anti-canonical 1896 Plessy versus Ferguson case really comes to a head with what we are going to be talking about here today. And obviously, one cannot overstate the importance of us trying to make good on what Martin Luther King referred to as,
in a sense, we've come to our nation's capital to cash a check. When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. This note was a promise that all men, yes, black men as well as white men, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness.
So the discussion that we are going to have here today, and I want to be very clear about this, this is not a criticism of Brown by itself, nor is it an attack on desegregation. I'm okay with these cases. I believe they were correctly decided. My concern is how these judgments were implemented, and that is what I am going to be criticizing here. And those are two very different things. I just want to be clear about that. So, however, in the pursuit of ending this erroneous constitutional doctrine of separate but equal, what ended up happening is the court made up two equally erroneous doctrines whose harm to the people of these several states has been every bit as destructive as the harm that arose from Plessy and from the idea of separate but equal. To understand where this comes from, let's start by taking a look at the Constitution's Supremacy Clause in Article 6. This says that this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made, shall be the supreme law of the land. So, the Constitution is the supreme law of the land, as are all laws and treaties made in pursuance thereof. But what about decisions of the Supreme Court? Are Supreme Court rulings on the meaning of the laws themselves the supreme law of the land? When the Supreme Court hands down an opinion, is that opinion the Supreme Court hands down functionally an amendment to our Constitution? And if so, when that case, if it is overruled, is that essentially the same thing as striking out the amendment? So does this, and furthermore, does the idea of judicial supremacy exist? Answering this question is going to take us back to one of the most fundamental cases in the entire corpus of American jurisprudence, and that will be the 1803 case of Marbury versus Madison. Now, there is a very good chance that when you first learned about this case, you learned that John Marshall created the doctrine of judicial review. This myth is so common that even if you are a lawyer, there's a fairly decent chance that you were told this in law school, that is precisely what happened. As my condescending tone surely suggests, that is just complete bullshit. Now, better sources talking about this case get it half right by referencing Federalist 78, which points to the fact that this principle was regarded as a fundamental part of our system of government right from the beginning, before the document was even ratified. So the judicial review comes from the judicial power given here arising out of Article 3, Section 2, Clause 1, which reads, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority." In brief, Marshall found that the Judiciary Act of 1789, at least in part, was unconstitutional. It purported to give the court a right to issue a writ of mandamus in a case where the court is acting in its original jurisdiction. This was inconsistent with the constitutionally limited jurisdiction of the Supreme Court, who have a duty to follow the higher law. That means that they must follow the Constitution over any statute. So Marbury doesn't say the court established supreme law, nor did it say that only the judiciary is the right place to interpret the supreme law of the land. Now, this idea of judicial review and interpretation of the Constitution by the government is not something limited to the Supreme Court. It's not even something that's limited to the judiciary. Anyone out there who has ever worked in a government job, either on a state or a federal level, will know that all employees in government have duly sworn an oath to the Constitution. All state and federal employees, in accordance with the oath clause in Article 6 of the Constitution, which reads, "The senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support the Constitution." So a good example of this is law enforcement. If they pull someone over and they want to search your car, a police officer honoring his oath must first weigh the constitutionality of those actions. He must ask himself, do I have probable cause, as is required under the Fourth Amendment, to conduct this search? And it goes down even further than that. Police is an easy one, but even a county commissioner who is deciding whether or not to, say, approve a parade permit must start with first principles. They must ask themselves first and foremost, will this decision to grant or deny this permit in any way be an infringement of the requesting party's First Amendment rights to peaceably assemble? So all government officials always have a duty to first and foremost defer to the Constitution. And each department is empowered to make these decisions for themselves. This is a legal doctrine that is known as departmentalism. And it was only well into the 20th century, though, that the courts began writing decisions that would begin claiming that their decisions themselves somehow were now the supreme law of the land. It's important to note that despite its constitutional provenance and majestic grandeur, the Supreme Court of the United States operates like any other court. Although its judgments bind the parties before the court, its precedents are not self-executing for non-parties. The distinction between the Supreme Court's judgments and precedents is often conflated, and it is often conflated specifically because of the case of Cooper v. Aaron. This is the landmark 1958 decision that was spurred on by the segregation crisis in the Little Rock, Arkansas school district. Cooper articulated two concepts under which the Supreme Court's precedents operated as binding judgments on everyone. First, the justices announced the doctrine that came to be known as judicial supremacy. And judicial supremacy said that a simple majority of the Supreme Court could now declare with finality the supreme law of the land. Second, Cooper asserted a principle that is named by the article by Josh Blackman as judicial universality. And he defines that as that the Supreme Court's interpretations obligate not only the parties in a given case, but also other similarly situated parties in later cases. Cooper, which was signed by all 9 justices, misrepresented that these two doctrines were basic and premised on a settled doctrine. This is simply not so. Rather, these were both novel assertions of judicial power that were and remain entirely inconsistent with how all courts, including the Supreme Court, operate. Though a careful study of the papers of Justices Black, Brennan, Burton, Clark, Douglas, Frankfurter, Harlan, and Chief Justice Warren, this article by Josh Blackman, that I'm getting a lot of this information from, exposes the constitutional origins of what he calls this irrepressible myth. Now, Cooper arose in a very tumultuous time in American history. Since the New Deal era, the court had been looking for the right opportunity to undo the ruling in the 1896 anti-canonical case of Plessy v. Ferguson that created the separate but equal mandate. This opportunity came in what will become one of the most important cases in the entire history of our republic. This is 1954's Brown versus Board of Education. At the time, nearly 24 states racially segregated their schools, but Brown only considered the constitutionality of the laws of 4 of those states, specifically Kansas, South Carolina, Virginia, and Delaware. Now, in a unanimous decision, the Warren Court found that segregated public schools violated the Equal Protection Clause of the 14th Amendment. However, the court did not order that all schools nationwide must desegregate immediately. Instead, the court ordered another round of oral arguments to decide how Brown should be implemented. And it wasn't until a full year later, in a case that was known as Brown versus Board of Education 2, often just simply called Brown 2, that the justices issued an order to the lower courts in Kansas, South Carolina, and Virginia. And it said, quote, "Enter such orders and decrees as are consistent with this opinion, as are necessary and proper to admit to public schools on a racially non-discriminatory basis with all deliberate speed the parties to their cases." End quote. So officials in these 3 states were now bound by the Supreme Court's judgment to integrate their schools, as the brief said, with all deliberate speed. Now, you may notice Delaware was missing from that list. The Delaware school had already found on its own that segregated schools were unlawful and had taken care of that of their own accord. But what about the states that were not party to Brown? This is where Cooper versus Aaron in 1958 comes in and tries to resolve this issue. So in 1955, the Little Rock, Arkansas School Board approved a plan for gradual integration. However, what was the so-called massive resistance of desegregation ended up spreading to Arkansas. Citizens approved an amendment to the state's constitution that opposed Brown and desegregation. Based on that amendment, a state court judge issued an injunction against members of the Little Rock School Board. They were ordered to stop the implementation of the federal court's integration plans at Central High School. Now, very often when the courts are deciding issues in a tumultuous time, out of necessity, they sometimes reach too far. And in all fairness, in the years since, the court has somewhat equilibrated on this case. Certain aspects of that decision they have relied on, certain aspects they have not relied on. Now, in Josh's article, The Irrepressible Myth of Cooper v. Aaron, he focused on 2 particular aspects of the Cooper decision. These are the things that he refers to as the irrepressible myths. And these are the 2 different concepts that he talks about that are often conflated, and those are the judgment of a court and the court's precedent. So when Smith sues Jones, there is no doubt that that decision binds Smith and Jones. This is a basic legal principle called estoppel procedure, but when Smith sues Jones, Bill cannot be bound by that case as he was not a party to it. To do so would violate not only the basic rules of procedure, but just general fairness. Yet, when it comes to the Supreme Court, people seem to flip this idea on its head. They will often take the attitude, well, the Supreme Court has ruled, that makes it binding on everyone, everywhere, right away. This is simply not the case. This cannot be the case, moreover. So, the Supreme Court's precedents are controlling for all courts. So, when the Little Rock Central High School said, I don't care, I am going to keep segregating my school, and I don't care what the Brown ruling said, that school opened itself up to being sued. At that point, a state judge or a district judge could bind you and enjoin you to comply with the ruling in Brown. But that additional step of converting a precedent to a judgment is very important, and especially so in civil rights litigation, though it's often not well understood or even really understood at all. The reason many people fail to understand this is precisely because of the outcome in Cooper v. Aaron. So this is due to the two aforementioned concepts that come from Cooper of judicial supremacy and judicial universality, where judicial supremacy says that a simple majority vote of the court can declare with finality the supreme law of the land. And judicial universality once again stems from the paper written by Josh Blackman with a co-author, Howard Wasserman. And this is the notion that the Supreme Court and their constitutional interpretations obligate not only the parties in a different case, but also parties in similar cases. That is to say, going back to our earlier example, when Smith sues Jones, they're now saying that their final judgment binds Bill. The court's unitary opinion in Cooper, which was signed by all 9 justices, which I cannot stress how very rare that is, says that these aspects were basic and relied on settled doctrine. The irrepressible myth takes the position that particular aspects of that decision are not correct. They were broad, novel, and unprecedented assertions of power that are inconsistent with how all courts operate, and yet 5 decades later, many of these myths still remain. Now, the phrase irrepressible myths comes from a paper written by John Hart Ely on what was called the irrepressible myth of Erie. And this was from the Harvard Law Review in 1974, challenging the orthodox interpretation of Erie Railroad v. Tompkins, which, I'll maybe get into that case someday. That is an insane case. It's just, I don't even know if I could explain it. But anyway, but that was a decision which seemed to purport a single command and 3 distinct standards laid out in the Constitution. And this concept of the irrepressible myth has since been frequently adopted by constitutional scholars to refer to any case, doctrine, or assertion made by the courts that has been factually disproven but seems to carry on all the same in the collective memory of constitutional lawyers, scholars, and amongst the general public. Given the continued existence of the myth in Cooper, which still persists 5 decades later, the irrepressible myth sought to bring something new to the discussion. And so, after Blackman spent a great amount of time examining the papers of Justices Hugo Black, William Brennan, Harold Burton, Tom Clark, William O. Douglas, Felix Frankfurter, John Marshall Harlan, and Chief Justice Earl Warren, the only justices who were excluded were Charles Whitaker, who did not have any papers. And the reason these papers were important is because the judgment was signed by all 9 justices. And even though Justice Brennan was the lead draftsman, the others were responsible for writing comments. And most often, more often than not really, justices ignore comments. But here, Brennan had to get everyone on the same page and actually, for the most part, listened to his brethren and incorporated their notes into the final opinion. Because of this, you can actually, this is really fascinating, look at the documents and develop something of a red line mentality and can track the changes in the drafts to see how this document evolved. And what the article by Josh Blackman through his research did was essentially create a coherent narrative of how the message evolved in this case, through 6 distinct drafts of the final opinion that was prepared in the course of only 10 days or so, which is remarkably quickly. Now, this all came about as part of the battle against the anti-canonical doctrine of Plessy v. Ferguson. And while challenges to institutionalized racial segregation can be traced back to the progressive era of the 1920s and the 1930s, and cases brought by the NAACP that challenged separate but equal, and which did lay the foundation for the proto-doctrine of what is now known as substantive due process, these early victories are what spurred the school desegregation cases in the 1950s that for the first time sought to take on and overturn Plessy directly. Now, this is where both the article and the modern story of desegregation officially begin with Brown versus Board of Education. And also, of course, its follow-up, Brown 2, which did not purport to desegregate schools immediately. Instead, Brown 2 ordered desegregation take place, quote, with all deliberate speed, end quote. The idea behind that now famous instruction was they should let the local courts who were on the ground craft mandates and injunctions to deal with each situation as it comes. Brown 2 applied to North Carolina and Virginia, and also to Washington, D.C., although that came from a companion case that was known as Bowling v. Sharp, and that dealt with school desegregation in the federal law, which was struck down as a violation of the Fifth Amendment's Due Process Clause. So next here we have Little Rock. The Little Rock Independent School District, they were not a party to Brown. And in fact, as it turns out, they actually argued as an amici to the court in Brown, but they were not themselves a party to the case. So, were they bound by the decision? The simple answer, using our earlier examples, when Smith sues Jones, is Bill bound? Well, the answer would be no. And as it turns out, the Little Rock School Board, which was elected at a time made up of mostly segregationists, decided that they were not going to go along with this unless they were absolutely dragged, kicking and screaming. So here's what happened. A district court in Little Rock issued a desegregation order to integrate the schools, especially Little Rock Central High School. So a federal district court took an injunction saying integrate Central High School, but in a bizarre twist, a state court in Pulaski County, the Pulaski County Circuit Court, issued an injunction saying don't integrate the school. So the federal court was saying integrate, the state court was saying do not integrate. Now, some people would assume that, of course, the federal court prevails, but that's simply not the case. And nothing in the Supremacy Clause states that that should be the case. State courts and federal courts have equal license to interpret the Constitution. The conflict, though, arises when you are a state official asking yourself, which court do I listen to? If I listen to the federal court, the state might hold me in contempt. If I listen to the state court, the federal court could hold me in contempt. Only the U.S. Supreme Court could resolve that kind of tension. This is how the conflict in Little Rock began. And then it got worse as it became what you could really kind of refer to as a game of injunctive whack-a-mole. A district court issued a ruling binding the school board. So then, the governor shows up with the National Guard to block the black children from entering the school. So the district court issues an injunction against the governor and the National Guard, and what happens next? The Little Rock Police Department, who are not bound by that prior injunction, show up, and they start keeping these kids from entering the school. At this point, we do have a crisis because the officials are taking advantage of this distinction we've been talking about between judgment and precedent. Now, if you find yourself wondering where these Arkansas racists got this really almost quasi-evil tactic from, the answer may surprise you. That is Abraham Lincoln. A lot of this stretches back to the abolitionist movement and Lincoln's argument about the Dred Scott decision that it only controlled Dred Scott and Stanford because the U.S. government was not a party to the case. They didn't even file an amicus brief in that case. They couldn't be bound by Chief Justice Roger Taney's now reviled ruling, and so the Southern Manifesto traces its roots right back to Lincoln. And even more bizarrely, Brennan's precedent in Cooper traces back to, of all people, Stephen Douglas. Stephen Douglas didn't have to abide by Dred Scott. The Supreme Court is the keeper of the Constitution, so everything is backwards, right? The segregationists are siding with Lincoln, and the Supreme Court and the federal courts are invoking Stephen Douglas. Everything is backwards. It is a bizarre aspect of human history, but sometimes that is how it goes. So eventually, President Eisenhower sent in troops in a now very famous scene where they escorted the Little Rock Nine up these steps to the classroom and escorted these 9 truly brave students to class. Eisenhower was deliberate and very careful in his wording in the executive order that he issued, citing the district court ruling as what he was enforcing. He didn't mention the Supreme Court. In fact, one of the biggest criticisms held in regard to Eisenhower was he never came out in support of Brown. He always remained ambivalent and simply never said much about it. But he said he will enforce the district court. Schools could not disregard it. So at that point, students were escorted into school, but the district court did something that was very, very much unexpected. The district court granted a 30-month extension for the integration plan. He said this was because there was chaos and bedlam and turmoil. Therefore, he couldn't allow this integration order to go into effect. So the district court said that they were going to put this on hold for 30 months, which is basically 2.5 full school years. Now, the Eighth Circuit then reversed that, saying that with all deliberate speed, that famous phrase from Brown 2, that with all deliberate speed means now. The Eighth Circuit stayed its decision, then an appeal went to the Supreme Court. And we should be careful here to remember that with Cooper versus Aaron, what was at issue were the decisions by the members of the school board. It wasn't a case of Governor Faubus versus Aaron. There was another very famous case involving Governor Faubus. This was not it. Now, the Supreme Court held that the 30-month extension was not consistent with all deliberate speed. As Chief Justice Warren stated, quote, merely having chaos on the ground did not justify 2 full years of continuing non-integration, end quote. But the court didn't stop there. Upon review of the opinion of the Eighth Circuit Court, they said the first 17 pages of the opinion is enough to dispose of this case. But the court moves on to 2 last pages of the public opinion, which is almost exclusively the focus of the second part of this article. And this section answers whether the Arkansas governor was bound to enforce Brown, even though he was not a party to the case. And this is where the court develops these 2 myths that we started with at the beginning. First, judicial supremacy. There is a single sentence in Cooper that sums up everything very well. The court says, quote, the interpretation of the 14th Amendment enunciated by the court in the Brown case is the supreme law of the land, end quote. That is to say, it's not just the 14th Amendment that is the supreme law of the land, it's the court's interpretation of that amendment that is the supreme law of the land. The second principle, which this article again calls judicial universality, which really the best summary for what this is found in a book written by Justice Brenner called Making Democracy Work. And in it, Brenner wrote, quote, the court in Cooper actually decided that the Constitution obligated other government institutions to follow the court's interpretation, not just in a particular case, but in similar cases as well, end quote. Now, in Blackman's article, he correctly asserts that neither of these statements can possibly be true. If a simple majority vote in the Supreme Court could be declared the supreme law of the land, and the other majority could not change it absent a constitutional amendment, and under our foundational principles of jurisdiction, in Smith versus Jones, courts can only bind the parties in the given case. The mere fact that the Supreme Court is supreme doesn't change these facts. And critically, with respect to judicial universality, no court since has ever reached this conclusion. And with respect to both principles, no courts before have ever reached those conclusions. This was very much a product of a very serious crisis that this article freely concedes, and I will emphatically agree, was above the justices' power, and this history reveals that they didn't do much. In the years following Cooper, they didn't even end the crisis in Little Rock that continued unabated. Immediately after Cooper was decided, Arkansas's governor transferred, and this is incredibly sneaky and underhanded. He essentially, immediately after Cooper, the governor, Governor Faubus, transferred all the public schools to private charters, thereby getting out of the state action doctrine. They were no longer bound by the 14th Amendment, so for a full year, there was literally no public school that existed in the city of Little Rock. Now, what broke up this logjam? It wasn't the court. It was a more moderate group of members being elected to the school board. They then agreed to engage with the reintegration plan. So despite this noble opinion in Cooper v. Aaron, it really had absolutely zero effect. It had no effect whatsoever in the short term. And that is an important principle when you hand someone supremacy. It doesn't go very far. And the most telling sign is that 5 years after Cooper, is that after all was said and done, districts from the South basically ignored it. Did the Supreme Court ever grant certiorari? Not even once, despite numerous cert petitions from segregated school districts across the South. The court wouldn't take any of these cases and just looked the other way. And if you're not familiar, a writ of certiorari is what the court orders when it's considering taking up a case. Whoever is trying to appeal the case files what they call a cert petition, and they're asking the Supreme Court to hear the case. And then if the court grants cert, that means they are agreeing to hear and take up the case. So what I'm saying here is that despite numerous segregated school districts filing cert petitions, asking the court for help across the South to deal with the problem of continued segregation, the court refused to take those cases. Now, it's really easy if you are a lawyer in Washington, D.C., essentially sitting in a marble palace issuing these decisions. It is a very different matter than putting them into effect. Now, the third part of this article traces the evolution of the doctrine of judicial supremacy and universality throughout these 6 drafts of the Cooper opinion that Blackman researches and was able to identify. While it wasn't always clear which drafts were which, there was, in various justices' papers with different dates and different red lines on them, but he was ultimately able to identify 6 distinct drafts of the case. And this paper illustrates the way the justices grappled with how to establish the doctrine of supremacy and universality. And the main question is this: could these doctrines be supported by past precedent, or does it merely follow from these precedents? And at first glance, answering that question might well be mistaken for judicial sophistry, but it is in fact much more. What makes this a very big deal is the court said these doctrines are basic and well settled. That would mean that this case must have been essentially decided 200 years ago. But what you see with each successive draft is that they move away from these precedent rules that we can build upon that follow from it, but that is a very different principle from saying it is well settled doctrine. Now, what you see with each successive draft is that they move away from these precedents, and that now these precedents confer a rule that is a very different in principle than it was in practice. And among the leading cases are Article 6 of the Constitution, which includes the Supremacy Clause and the Oath Clause we mentioned. Major cases are Marbury versus Madison from 1803, United States v. Peters from 1809, and while Peters is not well known or often studied, it was nevertheless a fairly significant case, and a series of cases that have come to be known the Booth case. Now, this series of cases, beginning with Booth in 1854, was out of Wisconsin Supreme Court, and a case known as Abelman v. Booth of 1859. And these were from the U.S. Supreme Court. The Booth case dealt with whether a Wisconsin state court could issue habeas petitions for a federal prisoner. That is when someone tried to obstruct the capture of a slave, they were thrown into federal custody. So could a state court free a prisoner in a federal court? This was a really important case that no one tends to talk about today. This was Justice Taney's other major opinion that nobody wants to talk about. But it's a very big case all the same. The last case to mention is Sterling versus Constantine from 1932. This is a great Texas case where the governor declares martial law and basically tries to put limits on the production of oil in his own state. And there was a lawsuit filed in the state in which he stated he was not subject to a court's jurisdiction because they were under a state of martial law. Now, that one is a very fascinating case. But none of these stand for the proposition which Cooper cited and which the research done for this article suggests, that the judges realized this because with each successive draft, the court relied less and less on these precedents. They more or less said, well, let's use these rules and build upon them. These changes acknowledge that the court never before claimed such a power, such as supremacy or universality. They were breaking new ground. Now, the mere fact that they were breaking new ground doesn't mean that they were wrong. Very often, courts make new rules, and we can easily constitutionally justify them. But these claims were novel and new and not supported and have not been used before or since, which is why they can safely be called myths. They existed to deal with this exigency of segregation, which was an unquestionably awful situation that needed to be dealt with. But in hindsight, people have gained a little bit of clarity, and as has been mentioned before, ultimately these judgments had virtually no effect on the school districts that did an end run around these rulings by transferring the schools from public to private charter. And once this doctrine was laid bare, no court, no matter how high in stature, can force people to accept a judge's interpretation of the Constitution. The Supreme Court's authority is, at best, merely persuasive. The last part of Blackman's article focuses on how Cooper has been developed in the last century. Now, the court has not shied away from the principle of judicial supremacy. It's provided for in cases such as Powell v. McCormick of 1969, the one-person, one-vote case of Baker v. Carr from 1962, and the case of United States v. Nixon in 1964, to name but a few. But in those cases, there was no meaningful resistance to the court's interpretation. After the Supreme Court ruled on United States v. Nixon, President Nixon turned over the documents and resigned shortly thereafter. It was only in slavery and segregation that you found such massive resistance to the Supreme Court's opinions. Indeed, after Cooper was decided, people just disregarded it. despite all best efforts, neither Josh Blackman during his research into this case, nor me during my own research into his research, could find a single example of the court using Cooper as precedent for judicial universality, not even during the massive resistance. So, Justice Brenner, who really encapsulates this theory, as a matter of fact, can't really peg down where this doctrine is in Cooper. And this only lends further credence to calling Cooper a myth. It's not that it actually says this, but I think it's how people have understood it to be said. In fact, there have been some lower court decisions that have said that opinions issued by the U.S. Court of Appeals are binding on everyone. In other words, if the Ninth Circuit issues a ruling, it binds the government everywhere. This was a Reinhardt opinion. Now, you have a similar decision in the Southern District of New York as well, but these have really ultimately gone nowhere. But at the bottom, the Supreme Court, and it cannot be overstated how important this last bit is here. At bottom, the Supreme Court is still a court and follows the usual rules of a court. Its precedent is persuasive to everyone, state courts and federal courts alike, but its judgments are only binding on named parties. Stating the principle of judicial supremacy or of judicial universality in the absence of antagonism is simple enough. When trying to put them into effect, however, they are exposed as mere myths. Well, that is going to do it for me here today. I do hope that you enjoyed the show and you found it interesting and informative. And just if you are not subscribed to the channel, you may want to do that real quick right now, just to make sure that you always find out when I put out new videos. I don't put things out on a set schedule per se. It's not like weekly necessarily. So it helps if you're subscribed to the channel, just to make sure that you are always notified when new material goes up. If you have any comments at all about this, I would genuinely love to hear from you. And I mean, let me know. Do you agree with the court's ruling in Cooper? Do you disagree with it? What do you think of Josh Blackman's research, or my summation of it? I mean, did it change your mind on anything, or do you have a different opinion that you think you can sort of change my position on from this? And I'm genuinely interested to engage with you guys about questions like this. So let me know. Leave a comment down in the comment section. And what else? Oh yeah. I would say if you guys can take a minute as well and go check out the Patreon page that I had put up, and go read that article that I had wrote where I was talking about these avenues of funding and possibly becoming a patron, and why, what you would be helping with. If you would go and do that and take a look at that and read it, and just consider putting your financial faith behind the show, it would really mean a lot to me if you would even just take the time and read it and consider it. And then finally, as always, I ask that if you enjoyed this particular episode, just take a minute right now and think of one other person you know who you think would also enjoy hearing this episode, and just take a moment and send them an email or shoot them a text, and just share this episode with them, and let them know that they should check it out and they might like it. And if you would help me grow the show that way, I would really, really be truly grateful for that. And if you hated the show today, I would ask you just take a minute and think of one person you know who would also hate the show very much as well. And just take a moment and share the show with them. Let them know that they'd really hate it and they should check it out, because frankly, I'm a masochist, and to be honest, your hate gets me off. So anyways, this has been Categorical Imperatives. I have been Lockean Liberal, and of course, as always, delenda est Carthago.